So I tried to take the high road on the situation, but unfortunately, it's under construction. But no, to be serious, this is just friendly educational banter. I want to rebut some things that Sis said, because she was going in on some Moors, not all of us. But you know, an attack on one is kind of an attack on all. So without further ado, let's get into why this term Indian is such a misnomer, and what their true political status is according to the United States government themselves.
Round one. Fight!
First, you already know how I'm coming with the book reference. We're obviously going to go to the section pertaining to Indians. Section 1, General Considerations. Indian is the name given to the Aboriginal inhabitants of America. Indians, quote unquote, is the name given by the European discoverers of America to its Aboriginal inhabitants. The term Indian is used in several contexts, including biological descent, cultural identity, and legal status. And we know that legal status is that which is created by law. And we just read who created this status. So off rip, if you're using the term Indian, you're using something that was given to you, not something that you were prior to that name being given to you.
Perfect.
Now, let's continue. Federal regulation in general. The United States Constitution vests the federal government with exclusive authority over relations with the Indian tribes and makes Indian relations the exclusive province of federal law. There exists a unique relationship between the federal government and Indian tribes, and the federal government possesses plenary powers over tribes. Congress's power over Indian matters derived from the Constitution's Indian Commerce Clause and its treaty power. The federal Constitution grants Congress broad general powers to legislate in respect to Indian tribes. And this is important because a lot of people claim that Indians are a nation or a separate and sovereign nation. But we're going to debunk that in a little bit. The Indians are subject to the jurisdiction of the United States. Where does that sound familiar? And Congress has full power to legislate concerning their tribal property, and such power is plenary and not dependent upon a treaty. Tribal sovereignty and federal plenary power over Indian affairs, taken together, sharply circumscribe the power of the states to impose a citizen-like responsibility on Indian tribes, i.e. you are subordinate. And we know in law, subject to means liable, subordinate, subservient, inferior, obedient to, governed, or affected by. Let's go to Section 9, Citizenship. By statute, Indians born in the United States are citizens. A person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe is a national and citizen of the United States at birth. And I know some of you are going to jump at this national part, but we're going to get to that too. Indians born in the United States and subject to its jurisdiction are citizens of the state in which they reside. It has been held that under the 14th Amendment, which we are all against, Indians are citizens of the state wherein the reservation is geographically located. So while their status may be a tad bit different from the everyday 14th Amendment citizen, they are nevertheless still 14th Amendment citizens, subject to the jurisdiction of the United States.
Perfect.
And there's a lot more that we can go over in this book, but I want to start reading from case law. First case, the Cherokee Nation versus the state of Georgia, Supreme Court of the United States. Though the Indians are acknowledged to have an unquestionable and heretofore unquestioned right to the lands they occupy, until that right shall be extinguished by a voluntary cession to our government, yet it may be well doubted whether those tribes which reside within the acknowledged boundaries of the United States can with strict accuracy be denominated foreign nations. They may, more correctly, perhaps be denominated domestic dependent nations. So how can you be sovereign yet dependent? They occupy a territory to which we assert a title independent of their will, which must take effect in point of possession when their right of possession ceases. Meanwhile, they are in a state of pupillage. Their relation to the United States resembles that of a ward to his guardian. Remember, Indian is a legal status, and this is the legal status of an Indian. They look to our government for protection, rely upon its kindness and its power, appeal to it for relief to their wants, and address the president as their great father. How fucking disrespectful is this shit? They and their country are considered by foreign nations, as well as by ourselves, as being so completely under the sovereignty and dominion of the United States that any attempt to acquire their lands or to form a political connection with them would be considered by all as an invasion of our territory and an act of hostility. So you're considered by the international community. However, it's acknowledged that you're in the subordinate status, which is why majority, if not all of them, don't have their separate passports. This case is from the 1886 United States Supreme Court case of United States versus Kagama. Perhaps the best statement of their position is found in the two opinions of this court by Chief Justice Marshall in the case of the Cherokee Nation versus Georgia, which we read, and in the case of Worcester versus the state of Georgia. In the first of the above cases, it was held that these tribes were neither states nor nations, had only some of the attributes of sovereignty, so not all, but some, and could not be so far recognized in that capacity as to sustain a suit in the Supreme Court of the United States. So they didn't have the status to, maintain or sustain a suit, as it was said there. In the opinions in these cases, they are spoken of as wards of the nation, pupils as local dependent communities. They are politically saying, you niggas are our sons. This is from another case. The suit was brought on the theory that these Indians are wards of the United States and that it therefore has authority and is under a duty to protect them in the ownership and enjoyment of their lands. Many provisions have been enacted by Congress, some general and others special, to prevent the government's Indian wards, so governments is possessive, Indian wards from improvidently disposing of their lands and becoming homeless public charges. With this explanation of the status of the Pueblo Indians and their lands and of the relations of the United States to both, we come to answer the questions propounded in the certificate. To the first question, we answered that the United States is not barred. Our reasons will be stated. The Indians of the Pueblo are wards of the United States and hold their lands subject to the restriction that the same cannot be alienated in any wise without its consent. Resolution of the instant issue turns on the unique legal status of Indian tribes under federal law and upon the plenary power of Congress based on a history of treaties and the assumption of the guardian ward status to legislate on behalf of federally recognized Indian tribes. So being federally recognized is pretty much no different than you saying that you're that name on a social security number. You are admitting to and applying for a slave status because they give you allotments. So how are you going to be sovereign yet admit you're under the same people who occupied and took over your place in the first place? Let's go to Morton versus Mancari, Supreme Court of the United States. The preference as applied is granted to Indians not as a discrete racial group, but rather as members of quasi-sovereign tribal entities whose lives and activities are governed by the BIA, Bureau of Indian Affairs, in a unique fashion. Subject to means governed by, and they are subject to the jurisdiction of the United States, aka Congress, which is located in the District of Columbia. So the other case I read from is Santa Clara Pueblo versus Martinez. Now let's get back to this case. Although we rejected the notion that Indian tribes are foreign states for jurisdictional purposes under Article 3, we have also recognized that the tribes remain quasi-sovereign nations which, by government structure, culture, and source of sovereignty, are in many ways foreign to the constitutional institution of the federal and state governments. What does quasi or quasi mean? Resembling, having some but not all of the features of. So you have some but not all the features of sovereignty. Not like this definition. Seemingly, apparently, but not really. So to make you feel better about yourself, they allow you to be sovereign in some aspects. And according to law definition, quasi, as if, almost as it were. So in law, quasi is synonymous with color and appearance, semblance, or simulacrum, as distinguished from that which is real. And that's why quote-unquote Indians are included in BIPOC, Black Indigenous People of Color. Now, let's get back to the case law that absolutely shits on Indians. Oliphant versus Suquamish Indian Tribe, another Supreme Court case of the United States. Indian tribes do retain elements of quasi-sovereign authority after ceding their lands to the United States and announcing their dependence on the federal government. Reading below, Indian reservations are a part of the territory of the United States. Indian tribes hold and occupy the reservations with the assent of the United States and under their authority. Upon incorporation into the territory of the United States, the Indian tribes thereby come under the territorial sovereignty of the United States, and their exercise of separate powers is constrained so as not to conflict with the interests of the overriding sovereignty. Their rights to complete sovereignty as independent nations are necessarily diminished. And let's look up the attributes of sovereignty in the law dictionary. The international independence of a state combined with the right and power of regulating its internal affairs without foreign dictation. It is the supreme power by which any citizen is governed, and it is the person or body of person in this state to whom there is politically no superior. Lastly, I want to read you something from Muammar al-Gaddafi, who successfully nationalized Libya and was about to start an African central bank backed by gold currency. Listen to what he says about tribalism. The nation is the individual's national political umbrella. It is wider than a social umbrella provided by the tribe to its members. Tribalism damages nationalism because tribal allegiance weakens national loyalty and flourishes at its expense. In the same way, loyalty to the family flourishes at the expense of tribal loyalty and weakens it. National loyalty is essential to the nation, but at the same time, it is a threat to humanity. So this very argument of whether we're Moors or whether we're Indians, which I just proved that we're not, is compartmentalizing us and dividing us even further. Really, we're all the same people, indigenous, but we need a nationality, which is Moorish American. Some of you don't agree with that, and that's okay. So yeah, I teach people how to get free houses. Go get my Adverse Possession ebook. Peace.